The first note I took was on June 3rd. Blue pen, yellow legal pad. The handwriting was neat because I was still trying to impress people. By August, the handwriting was a crime scene. But by then, so was everything else. Let me tell you something about ambition. Ambition, in its purest, most uncut form, is basically just arrogance that found a business plan. And I had it bad. I had it the way people get religion, sudden, total, and with absolutely no humility about the timing. I was 22 years old, finishing my third year of pre-law at Temple University, and I had just landed a summer internship at Callaway Briggs & Chase, one of the oldest and most prestigious law firms in Philadelphia. The kind of firm where the conference rooms have oil paintings of men who died before the zip code system existed. The kind of firm where the letterhead alone has intimidated people into settlements. The kind of firm where the carpets are thicker than most people's retirement accounts. My name is Marcus Webb, and the first mistake I made had nothing to do with the notes. The first mistake was thinking I was the smartest person in any room I walked into. The notes were the second mistake, but we'll get there. I need to back up, because this story doesn't actually start with me. It starts 3 years before I ever walked through those brass-handled doors on Chestnut Street. It starts with my Uncle Ray. Raymond Webb is 55 years old, built like someone who played college football and never quite let himself stop being that person. He owns a mid-sized commercial plumbing and HVAC contracting company in South Philly, Webb Mechanical, that he built with his hands and his credit score over about 2 decades. Not glamorous work. Not the kind of thing that gets you into the Philadelphia Business Journal's 40 under 40. But it was his, and it was profitable, and it had put 3 of his kids through school and kept his wife in a house she loved on a street she'd chosen. My uncle was the kind of man who understood that self-made was both a description and a promise you kept to yourself every morning. 3 years ago, Webb Mechanical got into a commercial dispute with a general contractor over a large municipal project. A school renovation in the Northeast that had gone sideways in the way that municipal projects always go sideways, which is to say slowly, expensively, and with everyone pointing at everyone else. The dispute was complicated. It involved change orders, subcontractor liens, city compliance issues. Ray needed a lawyer. Someone pointed him toward Callaway, Briggs & Chase, who had a whole municipal litigation practice, and whose reputation was, let's say, sterling. Like a silver fork that's been polished so many times you forget it was ever used to eat anything. He hired them, paid a significant retainer. The case dragged. And then, somewhere in the machinery of that dragging, Ray's money started moving in ways that didn't quite line up with the work being done. Billing that didn't match the timesheets. Fees assessed for consultations that Ray had no record of requesting. A settlement that came in substantially lower than the preliminary advice he'd received, and which arrived with a bill for services that somehow totaled more than the settlement itself. By the time it was over, Ray had paid Callaway, Briggs & Chase $240,000 in legal fees, received a net settlement of roughly $80,000 after expenses, and walked away from a dispute that should have been worth 3 or 4 times that, with nothing but a folder of invoices that didn't add up, and a handshake from a man who didn't look him in the eye. I know this because Ray told me. Not in a dramatic way. Not the way wronged men in movies deliver their grievances in front of fireplaces with a glass of scotch. He told me at a family barbecue the summer before my internship, at a picnic table, eating a hot dog, almost as an aside. "They stole from me, Marcus," he said. "Professional, slow, with receipts. And I can't prove it because they're the ones who know how receipts work." I nodded. I stored that somewhere. And when the internship posting came up through Temple's Career Services portal, Callaway, Briggs & Chase, summer associate program, paid position, direct placement with a senior partner, I didn't hesitate. I applied. I got it. I told my advisor it was because of my grades and my personal statement and my demonstrated interest in civil litigation. I told myself it was because of Ray. Neither of those things was the whole truth. That's the problem with 22-year-olds on missions. The mission and the ego are so thoroughly tangled up that you can't find the end of one and the beginning of the other. Callaway Briggs and Chase occupied 4 floors of a building on Chestnut Street that had been built in 1923 and renovated in a way that carefully preserved the feeling of 1923, while adding things like functioning Wi-Fi and a coffee machine that cost more than my car. I walked in on the morning of June 3rd wearing a suit I'd bought on sale and pressed the night before, carrying a leather portfolio my mom had given me as a graduation-adjacent gift, and containing inside that portfolio a yellow legal pad and 2 blue pens. Not black. Blue. I had read somewhere, I don't remember where, that blue ink photographs better in document scans. I had already decided at this point that everything I wrote would eventually be scanned. The receptionist's name was Diane. She had the practiced warmth of someone who'd been welcoming young men in cheap suits for years, and had developed a fondness for them the way you develop fondness for seasonal things. Genuine, but impersonal. She handed me a visitor badge and a welcome packet and told me that Howard Chase's assistant would be down to collect me at 9. Howard Chase. Senior partner. Named on the door. 60 years in the profession compressed into 58 years of actual life, because men like Howard Chase seemed to have started working in the womb. He was the partner Ray had dealt with, or rather, the partner whose name had been on Ray's case files, though Ray said he'd rarely seen the man himself. Mostly a junior associate named Pratt, who had since left the firm, and a paralegal who apparently managed the actual day-to-day. Howard Chase was the name you paid for. The junior associates were what you actually got, which was, I would learn, entirely by design. His assistant was a woman named Carol who wore reading glasses on a beaded chain and moved through the office like she'd memorized the floor plan, and was mildly disappointed by how often other people hadn't. She took me up to the 31st floor, pointed me at a waiting area with a view of City Hall, and told me Howard would be with me in 11 minutes. He was with me in 14. I noted this. Marcus. He said my name the way politicians say names, present tense, warm, hollow. He was tall, silver-haired in a way that suggested he had not chosen the color so much as earned it, and he wore a watch that I would later learn cost more than a semester of my tuition. He shook my hand with the grip of a man who'd been using handshakes as communication devices for 30 years. We're glad to have you this summer. Temple, right? Good school. Good program. Yes, sir. Thank you for having me. You'll be shadowing me for the summer. Real exposure. Not filing and coffee. Though you may be asked to file things and coffee is available. He smiled at the old joke with the ease of a man who'd been making old jokes for decades. I want you in the room. I want you to see how cases actually move. Can you keep up with a fast pace? Absolutely, I said. Good. He looked at the portfolio in my hands. You take notes? Religiously, I said. Something crossed his face. I thought at the time that it was approval. I was wrong about what it was, but I wouldn't know that until much later. The first 2 weeks were, I will admit, genuinely educational in ways that had nothing to do with my agenda. Howard Chase was, objectively, a brilliant lawyer. Not in the academic sense, not the way my professors were brilliant, which was the brilliance of people who had read everything and done some of it. Howard was brilliant in the operational sense. He understood how litigation moved, how negotiations breathed, how the gap between what a case was worth and what a client would accept could be managed over months of carefully calibrated communication. He was efficient. He was charming. He was precise. He was also, I would come to understand, running what amounted to a slow-motion extraction machine. But let me not get ahead of myself. The notes came first. I took notes on everything: client meetings, internal strategy sessions, hallway conversations I wasn't technically part of but happened to be standing near. I noted the time, the participants, the substance of what was discussed. I noted discrepancies when billing discussions happened near me. An offhand comment about a client's retainer balance, a number that didn't match what I'd heard quoted to the client themselves 3 days earlier. I wrote it all down in my blue pen on my yellow legal pad, and at the end of each day I typed it up on my personal laptop and saved it to an encrypted drive I kept in a locked box in my apartment. This was, I want to be clear, an absolutely insane amount of effort for a 22-year-old intern. But I was running on a specific kind of fuel, the kind that doesn't come from coffee. The office had a rhythm I learned quickly. Howard typically arrived at 7:45, spent the first hour alone with Carol going through correspondence, and was available to associates, and, by extension, to his assigned shadow, from 9. The afternoon was usually client meetings or court prep. Fridays were billing review, which Howard did with a man named Gerald Fenwick from the accounts department, in a glass-walled conference room on the 30th floor. I was not invited to billing review. I noted this also. It was during my 3rd week that I met Nina Salazar. She was 30 years old, a paralegal who'd been with the firm for 6 years, which meant she'd arrived young and stayed longer than most people at her level did. She had an office, not a real office, a converted storage room with a window that looked at a wall. But she had walls and a door, which at Callaway, Briggs & Chase was currency. She wore her dark hair back when she worked and down when she was in the building but not working, and she had the particular competence of someone who has spent years being essential to people who don't fully understand that they need her. She knew where everything was. She knew how everything worked. She had been, I eventually learned, the paralegal on Ray's case 3 years earlier. I didn't know that at first. That came later, and it rearranged the whole architecture of what I thought I was doing. The day I met Nina, she appeared in the doorway of the small shared workspace they'd given me, really just a corner of a document review room, and looked at the legal pad open on my desk and said, without preamble, "You take a lot of notes for an intern." "I learn by writing," I said. She looked at me for a moment. "What's your name again?" "Marcus. Marcus Webb." Something in her expression shifted slightly. Not dramatically. Not the way it shifts in movies where the camera zooms in and the music changes. Just a small internal recalibration that I noticed and filed away because I noticed everything and filed everything. "Webb," she said. "Howard mentioned you were from Temple." "He did?" "He talks about his interns. He finds them interesting." She said this in a tone that made interesting sound like something between amusing and threatening. "I'm Nina. I work the municipal litigation accounts. You'll probably run into me a lot." "Looking forward to it," I said. She didn't respond to that. She just looked at the legal pad one more time and left. I underlined something I had just written. The sentence was, "Billing cycle inconsistency RE. Hartwell Matter, 4. 2 hours billed. Meeting ran 1.5 hours per Carol's calendar." I underlined it twice. The turning point. The real one. The one that changed the nature of what I was doing from personal grievance investigation to something considerably larger. Happened in the last week of June. I had been spending my evenings going through public court records, cross-referencing case numbers I'd overheard or glimpsed in documents with docket filings. This was tedious, largely fruitless, and the kind of activity that tells you a great deal about the quality of your own social life. But on a Thursday night, around 11 o'clock, sitting at my kitchen table with a bowl of cereal I'd stopped eating 40 minutes earlier. I found something. The Hartwell matter. A commercial landlord-tenant dispute. Public filings showed a settlement entered in the court record for $115,000. The billing records I'd managed to partially reconstruct from numbers I'd noted showed fees to the client totaling $108,000. That left the client, a property management company, with $7,000 and a settlement that, based on comparable cases I'd researched, should have been worth closer to $200,000 if properly negotiated. I sat with that for a while. Then I went back further. The Donahue construction matter. The Riverfront Development Group mediation. The Eisner estate settlement. The Cook commercial liability case. And then, at the very bottom of a thread I'd been pulling for 3 weeks, the Webb mechanical municipal dispute. 6 cases. Different clients. Different practice areas. Different associate teams. Same pattern. In every single matter, the gap between what the case settled for and what comparable outcomes suggested it should have settled for was significant. And in every single matter, the gap between the actual legal work performed and what was billed for it was also significant, and the two gaps pointed in opposite directions. The clients got less, the firm got more. And running through all 6 matters, in the billing records, in the staffing assignments, in the account management structure, the same name. Every time. Howard Chase. I remember the specific physical sensation of understanding something that large. It's not satisfaction. It's not even anger, not at first. It's more like vertigo, the floor suddenly being further down than you thought it was. I had come into this firm thinking I was looking for what happened to my uncle. What I found was that my uncle was one of 6 people I could document, and I was looking at 6 cases I could find in public records. How many had I not found? I opened a new document on my laptop. I labeled it Redundant Evidence Chain 1. I started a second document and labeled it Redundant Evidence Chain 2. And then I did something that, looking back, I want to attribute to some sort of strategic foresight, but was honestly just the paranoid instinct of a 22-year-old who had watched too many thrillers. I printed everything, twice, and put the second copy in a sealed envelope that I mailed to my own email address as a PDF attachment, and also physically mailed to a P.O. box I had rented 2 weeks earlier on a hunch I still can't fully explain. I told myself I was being careful. I was being overconfident in a new configuration. That's still not the same as careful. July began the way July in Philadelphia always begins, which is with a heat that is not just hot, but specifically resentful, as if the city has decided to make the warmth personal. The office was air-conditioned to the temperature of a pharmaceutical storage facility, which meant I wore a jacket inside all day and sweated through it the moment I stepped out for lunch. This is a very specific kind of misery that Philadelphia summers have perfected. I had started spending more time near Nina, partly because she had access to case management systems I didn't, and partly because something she had said in our first conversation, the way she'd said Howard finds interns interesting, kept resurfacing in a way I couldn't quite silence. I told myself I was cultivating a source. This was true. I was also, I should admit, genuinely enjoying talking to her. She was sharp in a way that the associates and partners weren't. Or rather, they were sharp in a way that had been directed at a specific target for so long it had become narrow. Nina's intelligence was broader, more sideways. She noticed things the way I noticed things, which meant we could have conversations that moved faster than conversations with most people. One afternoon in the second week of July, we were in the document review room together, her reviewing a production for a case I wasn't assigned to, me doing research I was supposed to be doing and mostly using as cover for reviewing my notes, when she said, without looking up, You know Howard has done something like this before, right? The intern thing. I looked up. Done what? Assigned an intern to shadow him for the summer. She turned a page. He does it every few years, usually someone whose family has a connection to a current or former client. He likes having, what does he call it? Informed perspective in the room. That's a generous way to describe it, I said carefully. He'd say it's mentorship. She still hadn't looked up. He does actually teach people things. That's the honest part. And the dishonest part? Now she looked up. She studied me for a moment in that same way she'd looked at my legal pad the first day we met, with a kind of calm assessment, the look of someone who is checking whether a door is locked before deciding whether to knock. He monitors what they understand, she said. There's a reason the interns in this program come from specific backgrounds. It's not generosity. I should have said something neutral. I should have nodded and redirected. Instead, I said, my uncle had a case here 3 years ago. Webb Mechanical. Municipal dispute. Nina's expression did not change, but something behind her eyes stopped moving for a second, the way a clock stops between ticks. I know that case, she said. I know you do, I said. We looked at each other across a table covered in documents for a long moment. The air conditioning hummed. Somewhere down the hall, someone was on a phone call, talking in the clipped rhythm of a man who bills by the hour and has therefore learned to speak without wasted words. How much have you written down? She asked. A lot, I said. How redundant is it? I blinked. What? How many copies? How many places? She was watching me with an expression I couldn't fully read, not hostile, not quite allied, somewhere in between, occupying a position I didn't have a name for yet. Single point of failure is a mistake. One copy, one drive, one storage location. That's not evidence. That's a document that can be lost. I stared at her. Why would you ask me that? She went back to her document production. I'm a paralegal, she said. I understand chain of custody. I didn't sleep well that night. Here's the thing about being overconfident at 22. It doesn't mean you're never right. Overconfident people are right sometimes, often enough that the confidence gets reinforced, which is exactly why it's dangerous. I had been right about a lot of things up to this point. The pattern was real, the documentation was solid, my methodology was sound. I had made a plan with actual strategic bones to it. And then I made the mistake that overconfident people always make, which is, I started trusting my judgment about people as much as I trusted my judgment about documents. I told Nina more than I should have. Not everything. Not the location of the encrypted drive or the P.O. box or the specific contents of the second evidence chain I was building. But I told her the scope of what I'd found. The 6 cases. The pattern. The magnitude. The names. I told her about Uncle Ray. I told her I was planning to bring this to the Pennsylvania Disciplinary Board. I told her I had documentation that could survive scrutiny. I told her because she was smart and she seemed to understand what I was doing, and because I was 22 and lonely in the specific way that people get lonely when they're carrying a secret that's too large for one person and that they can't tell anyone who actually knows them. She listened carefully. She asked precise questions. She did not express surprise at anything I said, which I should have found more alarming than I did. You know he'll find out, she said. Not might. Will. The firm monitors its own communications infrastructure. If you're doing any of this research on a firm machine. I'm not, I said. Or accessing any systems remotely. I'm not doing any of that, I said. She nodded. But you're taking physical notes in the building, every day, on a legal pad that you carry. Yes. That's a vulnerability. I know. I did know. I had known. But I had convinced myself that the innocuousness of the format, a kid with a yellow legal pad, what could be more expected, was its own protection. Nobody suspicious wrote things down by hand anymore. The analog was its own camouflage. I was wrong about this in a way that would have been funny if it weren't so specifically disastrous. 3 days later, Howard Chase asked to see my notes. I want to be precise about how this happened, because the precision matters. He didn't ask in a confrontational way. He didn't call me into his office and sit me across from him in the leather chair and stare me down. He did it in the hallway, on his way to a deposition, in the casual tone of a man asking about nothing important. Marcus, I've been meaning to ask. I know you take notes during our client meetings. I want to use them for training purposes, actually. For building out our intern program documentation. Can you get Carol a copy of what you've been working on? The elegance of this was, I had to admit, impressive in the way that a trap is impressive when you're standing in it. He'd given me a reason that made saying no sound paranoid and uncooperative. He'd framed it as a request rather than a demand. He'd done it in motion, casually, which gave me no time to prepare a response. And he'd said it in a way that made the legal pad, my specific, physical, yellow legal pad, the thing he wanted, rather than any digital record, which meant he already knew I was keeping one. Someone had told him. I handed him a version of my notes, not the real ones. I had anticipated at some abstract level that something like this might happen, and I had kept 2 running documents, the actual record, and a cleaned anodyne version full of observations about courtroom procedure and meeting structures and professional development insights that would bore a first-year law student to tears. I gave Howard's assistant Carol the boring version. I did this in a state of cold, crystalline panic that I managed to express as normal Tuesday afternoon behavior, which is the single most useful thing pre-law school taught me. Then I went back to my desk, and I thought about Nina. I thought about the questions she'd asked, the specificity of them. How redundant is it? How many copies? She hadn't been warning me. She'd been assessing the exposure. She'd been figuring out what Howard would be dealing with if Marcus Webb turned out to be a problem. And then I thought about the other thing she'd said. The thing I'd been half processing for 2 weeks and not quite letting myself land on. She'd asked precise questions. She'd asked about chain of custody. She'd asked about redundancy in a way that suggested she understood why redundancy mattered, not as a concept, but as a requirement. You don't ask about redundancy unless you're thinking about what happens when the primary source gets neutralized. Nina Salazar was not betraying me to Howard Chase. Nina Salazar was collecting evidence for Nina Salazar. And she had just found out that there was more of it than she thought, and that some of it was somewhere she couldn't access. I sat at my desk for a long time. The air conditioning hummed. The city baked 14 floors below me. And I thought about the difference between an ally and a parallel operator, and about how there was a third possibility I hadn't accounted for. Someone who was doing to Howard what I was doing to Howard, who had been doing it longer, who was better at it, and who had now found out I existed. I got up and walked to Nina's office. She was at her desk. She looked up when I came in, and I could see from the way her expression arranged itself that she knew I'd figured it out. "You told him," I said. "I told him you were thorough," she said. "I told him nothing he couldn't observe himself." That's a very careful answer. I'm a paralegal. Careful answers are the product. I leaned against the door frame. My heart was doing something aggressive in my chest, but I had decided on the walk over that I was not going to let it show. "How long have you been building your own file?" She looked at me for a long moment. Then she said, 4 years. Since before web mechanical. Since the Cook matter, which you apparently already know about. I have documentation on 6 cases, I said. Do you have more? She was quiet for long enough that the quiet was an answer. Then, you need to understand something. What you're doing, going to the ethics board, blowing the whistle, the righteous intern routine, that gets you a write-up in a legal ethics journal and maybe a letter of commendation from someone at the Bar Association. What I'm doing is bigger. What are you doing? Building a case that survives Howard hiring the best defense attorney in the state of Pennsylvania, she said. What are you building? I looked at her. Both, I said. She almost smiled. It wasn't a warm smile. It was the smile of someone who has been working alone for a long time and has just been handed a complication they're deciding whether to tolerate. Sit down, she said. I sat down. What Nina explained to me, over the next hour and a half in her small office with the window that faced a wall, rearranged my understanding of the situation in a way that was genuinely humbling. Not the fake humble of someone accepting a compliment, the actual, stomach-dropping kind. She had been keeping records for 4 years, not legal pads. She was smarter than that. But case management files routed through the firm's own systems in ways that looked like routine documentation, but contained embedded metadata that preserved timestamps and version histories that would be nearly impossible to dispute. She had copies of internal billing communications that showed Howard explicitly instructing associates on how to code time entries in ways that inflated billable hours without technically falsifying records. A distinction that mattered enormously in terms of criminal versus civil liability, but mattered not at all in terms of whether it was theft. She had correspondence between Howard and Gerald Fenwick in the accounts department that discussed, in terms sufficiently euphemistic to be deniable, but sufficiently explicit to be understood, the deliberate management of settlement negotiations to keep cases alive longer than optimal, generating additional fees at client expense. And she had something I didn't have: standing. She had been an employee. She had professional standing to file a complaint with the Pennsylvania Disciplinary Board in a way that an intern, and particularly an intern whose uncle was one of the aggrieved clients, demonstrably did not. My testimony was evidence, but it was compromised evidence. A judge or investigator looking at Marcus Webb's notes would see a motivated nephew. A judge or investigator looking at Nina Salazar's documentation would see a professional record. We needed each other. Not the way allies need each other. The way 2 people carrying different halves of the same thing need each other. Why are you doing this? I asked. Not the legal mechanics. Why? She was quiet for a moment. Because I helped, she said. I didn't know what was happening at first, but by the Donahue matter, I knew enough to suspect, and I kept doing my job. I kept processing the documents. I kept managing the client communications. I was good at it, and I told myself I was good at my job, which is true, but it doesn't. She stopped, chose words with visible care. It doesn't get you out of the room clean. I thought about Ray at a picnic table eating a hot dog, describing professional theft with the flat affect of someone who had accepted something and hated that he'd had to. My uncle said they stole from him with receipts. Your uncle is right, she said. And I have the receipts. The last 2 weeks of July were a study in pretending. I showed up every morning. I sat in Howard's meetings. I took my anodyne, useless version of notes in front of people who might be watching. I was helpful. I was enthusiastic. I asked good questions and made Howard look like an effective mentor, which I understood was why he'd asked for the notes in the first place, to assess whether the performance was convincing, and having found it convincing, to keep performing it. Howard Chase, in those 2 weeks, did something I had not expected, which was to be genuinely kind to me in a way that complicated my feelings about the entire operation. He introduced me to clients as our sharpest intern in years. He spent 30 minutes after a deposition prep session explaining the strategic logic behind a line of questioning in a way that was actually illuminating, with no agenda attached. One afternoon, walking back from a courthouse, he told me a story about his first year practicing law, when he'd been too scared to cross-examine a witness and had sat there and let an entire case slide away from him, and how he'd gone home that night and promised himself he'd never let preparation be the reason he lost again. He was self-deprecating about it. He looked, in that moment, like a man who had a story about failure that he'd told enough times to have made peace with it. I hated that he was a person. It would have been easier if he weren't. The humanizing thing about Howard Chase was also the most damning thing about him. He was not some cartoonish predator who enjoyed taking money from people. He was a man who had told himself a story, the story that his fees were justified by his expertise, that his clients received value, that the complexity of legal work entitled him to compensation they couldn't quite track. And he had told that story so many times that he believed it. He believed he was worth it. He believed the gap between what they got and what they deserved was just the cost of good legal work, and that the cost of good legal work was his to set. The worst villains aren't the ones who enjoy what they do. They're the ones who have a reasonable explanation for it. The ethics board hearing was scheduled for August 14th. I want to be accurate about how we got there, because the path was not straightforward. Nina had filed the initial complaint in mid-July through a channel that carefully separated my role from hers. Her complaint, her standing, her documentation, with my notes cited as corroborating material from a source who would be available to the board upon request. This was Nina's design, and it was precise. The board had jurisdiction. They had standing to compel documents from the firm, and the complaint was detailed enough that the usual defensive response, a flurry of counter-documentation designed to bury the original complaint in procedural complexity, was going to be substantially harder to execute. Howard found out about the complaint on August 9th. I know this because on August 10th, he called me into his office. The office smelled like old wood and leather and whatever expensive thing his cologne was, and he sat behind a desk that was probably older than the elevator I'd taken to get there. And he looked at me with an expression I can only describe as disappointed in the specific way of a man who is not actually surprised. "I want to ask you something," he said, "and I want you to think before you answer." "Okay," I said. "Did you share information about this firm's client files with anyone outside this office?" "No," I said. This was technically true. Nina was inside the office. He nodded slowly. "Your uncle was a client here. I know that. I knew it when you were hired." He let that land. "I hired you anyway. I want you to think about what that means." I looked at him. "What does it mean?" "It means I had nothing to hide," he said. "It means I thought it might be useful for you to see how a firm like this actually operates. It means I believed the best faith interpretation of your interest in this position." He paused. Was I wrong to? This was extraordinary. He was either genuinely confused about his own culpability, which seemed impossible, or he was attempting a specific kind of manipulation that worked by making the target feel guilty for being suspicious of someone who had given them no reason to be suspicious. These things are not mutually exclusive. "I came here to learn," I said. "And did you?" "More than you intended," I said. He didn't blink. "There's a complaint before the ethics board. It involves some of my cases. Yours will be among the voices that speak to my conduct this summer." He straightened a pen on his desk. "I want you to understand that my record over 40 years is extensive, and well documented. The cases in question represent a very specific interpretation of billing practice. Interpretations can be contested. They can, I said. That's why documentation matters. He looked at me. Something passed through his expression. Not quite anger, not quite respect. Some third thing that had elements of both. You remind me of myself, he said, when I was your age. I wanted to say, I hope not. I said, thank you, Howard. I walked out of his office and down to my corner of the document review room, and I sat very still for about 3 minutes. Then I took out my actual legal pad, the real one, the one I'd been keeping in my apartment, which I had brought in today specifically for this moment, and I wrote down everything he had just said: time, date, exact quotes, the pen positions, the pauses, every detail, and then I took a photo of the page and sent it to Nina. August 14th. The Pennsylvania Disciplinary Board hearing occupied a conference room in a building on Market Street that had all the warmth of a particularly committed accountant. Gray walls, fluorescent lighting that made everyone look like they were coming off a long flight, a table long enough to seat 15, occupied on one side by 4 board members and their counsel, and on the other side by Howard Chase, flanked by 2 attorneys from a defense firm in Center City, whose suits were considerably nicer than mine. I was in the waiting area. I had been told I would be called as a corroborating witness. The process, Nina had explained, would be procedurally slow and visually unspectacular. This was not a courtroom drama. This was a professional review process, and it would feel like a deposition conducted by actuaries. She was right. But slow and unspectacular doesn't mean unimportant. Howard's attorneys opened by characterizing the complaint as a misunderstanding of billing practice, rooted in a disgruntled paralegal's personal grievances and a young man's motivated misreading of documents he lacked the professional context to interpret. They were smooth. They were experienced. They had a presentation. The lead attorney had the specific kind of confidence that comes from winning a lot of these things, and it showed. Nina's complaint, submitted through an independent counsel the Bar Association had appointed to represent the complaining witness, was read into the record. It was 48 pages long. I know that because I had read every page. It was the most methodical document I had ever encountered. Not passionate, not angry, not rhetorical in any way, just sequential, dated, sourced. A record so complete that responding to it required addressing every individual entry. And there were 312 entries. Howard's attorneys had clearly read it. They had clearly prepared for it. They were clearly, underneath the composure, shaken by it in the way that people get shaken when they realize the thing they thought they understood is bigger than it looked. Then the door to the conference room opened, and Nina walked in. This was not scheduled. Her attorney had filed a motion the previous afternoon citing new corroborating material, which the board had granted the right to introduce. What they had not known, what Howard's attorneys had not known, was what the corroborating material consisted of. Nina sat down across the table from Howard Chase for the first time, I suspect, since the Webb mechanical matter settled. She placed a folder on the table. She opened it, and she began to read. What she read was a series of entries from her own internal documentation, the embedded metadata files, the billing communication records, cross-referenced with entries from my notes. The 2 sources aligned on date, time, client, and substance in a way that was not the product of coordination, because we had kept our documentation separate. They aligned because they described the same events from 2 different vantage points. 2 independent witnesses, 2 independent records, same facts. That's not corroboration. That's redundancy. And redundancy, in an evidentiary context, is nearly indestructible. I sat in the waiting area and listened to the procedural sounds through a door that wasn't quite soundproofed. And I thought about Ray at a barbecue. And I thought about Howard telling me I reminded him of himself. And I thought about Nina spending 4 years building something she could be proud of while doing a job she'd already decided she was going to leave the moment she'd finished it. When they called me in, I walked to the table and I placed my legal pad on the surface in front of me. 46 pages of handwritten notes in blue pen. Dated. Timed. Initialed. I looked at Howard Chase across the table. He looked back at me. For a moment. Just a moment. He looked genuinely old. Not the distinguished, silver-haired old of a man who's managed aging well, but the tired old of someone who has run a very long race and can see, from here, that the finish line he thought was ahead of him is not the kind you want to cross. He looked like a man whose own receipts had finally caught up with him. I answered every question they asked me. I was precise. I was calm. I referenced specific pages. I did not enjoy it the way I thought I would. The aftermath was bureaucratic and grinding in the specific way that institutional consequences always are, which is to say that it was satisfying in concept and tedious in execution. The Pennsylvania Disciplinary Board referred the matter to the Office of Disciplinary Counsel, which opened a formal investigation that ran from August through the following March. During that time, Howard Chase took a leave of absence from the firm. Gerald Fenwick from accounts resigned in October. 3 of the 6 affected clients, including Webb Mechanical, filed civil suits for fee reimbursement, 2 of which settled before the end of the year. The firm itself did not collapse. Callaway, Briggs & Chase is still on Chestnut Street. The oil paintings are still there. The carpet is still thick. The coffee machine still costs more than my car. Institutions like that don't collapse over one partner's misconduct, which is both a legal and organizational reality, and also one of the more depressing facts about how power distributes itself. What happened was recalibration. New oversight structures, new billing review processes, a very well-publicized internal audit. Whether that recalibration was genuine or cosmetic is a question I genuinely do not know the answer to, and I've stopped pretending I do. Howard Chase received a 2-year suspension of his law license, with reinstatement conditional on supervision. He did not go to prison. The billing practices, while exploitative, occupied a gray zone where demonstrating criminal intent to the standard required for fraud prosecution was, apparently, considerably harder than demonstrating it to the standard required for professional discipline. His attorney argued successfully that Howard had believed the billing was justified. The board found that belief professionally unreasonable. The DA's office found it not quite prosecutable. There is a gap there, a meaningful, infuriating gap. And it exists because the system that was supposed to prevent this is the same system that Howard spent 40 years learning to operate in. This is either a commentary on the system or a commentary on the limits of what individual action can achieve inside a system. I'm 22 and pre-law. I don't know which. Maybe both. Uncle Ray got $62,000 in a civil settlement. That's roughly a quarter of what he'd lost when you account for the difference between what his case was worth and what it settled for. He told me at Thanksgiving that he was satisfied. He did not look satisfied in the way that someone looks when they've received justice. He looked satisfied in the way that someone looks when they've confirmed something they already knew. The confirmation being a kind of comfort even when the underlying fact is grim. He shook my hand at the table before we ate. He held it for a long time. He didn't say anything. Ray has never been a man who says things he doesn't mean and knows it, which means he's learned to use silence for the ones that matter. Nina Salazar left Callaway, Briggs & Chase in September. She had a job waiting. She'd been negotiating it, apparently, in parallel with the complaint process, with the same methodical simultaneity she'd applied to everything else. She went to the public defender's office. Not a law firm, not corporate practice. I asked her once why, and she said, because the people there are running out of time from the minute they walk in the door. I thought about that for a while. I still think about it. She and I don't talk regularly. We talked a lot in August and early September, the way people talk when they're inside a thing together. Once the thing was over, the frequency dropped, which felt right for reasons I can't fully articulate. There's a category of person you meet at the exact moment when your lives intersect at a specific and unrepeatable angle, and the relationship is entirely defined by that intersection. And trying to maintain it after the angle closes feels like trying to describe a sound that has already ended. I think she understood that better than I did, and let it happen more gracefully. I went back to Temple in September. I started my 4th year. I was a mildly interesting person in my program for about 3 weeks, after which everyone moved on to being interested in themselves, which is the correct and natural state of affairs. I didn't apply for any more firm internships that fall. I spent a lot of time in the library. I took notes, still, on yellow legal pads with blue pens. Old habit, genuine habit, not performance anymore. And they were notes about evidence law and professional responsibility, and the specific, granular mechanics of how wrongdoing inside institutions gets documented, preserved, and used. There's a question I've been asked a few times since all of this, by people who know what happened, usually from classmates, once from a professor who'd heard the story in sanitized form. The question is, was it worth it? And I always pause before answering, not for effect, but because the honest answer is complicated in a way that the question's framing doesn't accommodate. Worth it for Ray? Partially. The 62,000 is 62,000. It doesn't make the whole thing right. Worth it systemically? Maybe, if the oversight changes hold, if the civil suits create precedent, if the public record of the investigation functions as a deterrent in the way public records are supposed to. Worth it for me? I don't know what currency to use to answer that. What I do know is this. I came into that building on June 3rd carrying a yellow legal pad and thinking I was running a revenge operation. And what I actually ran, what Nina and I actually ran, though that's her word to claim more than mine, was a documentation operation. Those are different things. Revenge is about a specific person and a specific wound. Documentation is about a record. Records outlive the people who created them. Records survive the intentions behind them. Records can be used by people you'll never meet for purposes you couldn't anticipate, in proceedings that happened 10 years after the notes were taken. The difference between revenge and justice, someone very smart once said to me, is whether you'd be proud of it in 10 years. I've been thinking about that. I don't think I'm proud of it. Exactly. Proud feels too clean. What I have is something more like, I understand what I did, and I would do it again, and the second time I'd do it better. I'd be less overconfident about the people and more careful about the process. I'd trust the documentation and distrust my own certainty about whose side anyone was on. I'd make the boring choices that produce durable results, instead of the dramatic choices that feel satisfying in the moment. I'd still use a yellow legal pad. Some habits earn themselves. The first note I took was on June 3rd. Blue pen, yellow legal pad. The handwriting was neat because I was still trying to impress people. The last note I took was on August 14th, sitting in a gray room on Market Street, dating and timing and initialing my pages the way a person does when they know they are building something that will outlast the day they're in. The handwriting by then was, as I said, a crime scene. But it was my crime scene, and it held up in every room it entered. That's not justice. But it might be the closest I'm going to get to it. And I've decided that closest is worth something. Not everything. Something. On most days, that's enough to work with. On the other days, I go back to the notes, the real ones, not the boring version. And I remember that the difference between a document and a weapon is just whether someone is willing to use it, and that the difference between using it for revenge and using it for something that lasts is whether you built it to serve one moment or all the moments that come after. I was 22 years old, and I thought I was the smartest person in the room. I was wrong about that, but I was right about the notes. And when the dust had settled and the filing was done and the outcomes were what the outcomes were, partial, imperfect, institutional, real, I was still holding the legal pad. That's more than most people walk out with.